Hello everyone. Today my topic of discussion is definition of transfer of property under Transfer of Property Act 1882. Before I start with the definition of this very term, I would like to mention here the preamble of this very act, which provides that wherever it is expedient to define or amend certain parts of law relating to transfer of property by the act of the parties. So, property can be transferred by two ways, either by act of parties or by operation of law. So, when we say or when we discuss the transfer of property by the act of parties, it means we are talking here about inter vivos transfers. Inter vivos transfers are those transfers which take place between two living persons, like sale, mortgage, lease, exchange, gift, and actionable claims. All these modes of transfer are covered under Transfer of Property Act 1882. So far as transfer by operation of law is concerned, it means those transfers which take place by the operation of law, like inheritance, succession, then transfer of property by the order of the court. Now, so far as the definition of transfer of property is concerned, Section 5 of this very act provides that transfer of property means an act by which one living person conveys property to one or more other living persons, or to himself or to one or more other living person. Such an act is called transfer of property. So it means this definition provides that if we want to cover any definition under Section 5 of Transfer of Property Act 1882, then it is necessary that in that transfer, first of all, there must be an act. Secondly, there must be conveyance. Conveyance means there is creation of new title or interest in the property. For example, in the case of sale, once the seller sells out his property to the purchaser, then after the sale, it is the purchaser who will get the title of the ownership in the property. So this is called conveyance. Thereafter, the third essential is that both the parties must be living persons. That means the transfer must be inter vivos transfers, like in the case of sale, lease, mortgage, exchange, actionable claims, and even in the gifts, both the parties must be living person. Furthermore, it is also not necessary that transfer, that means any person, seller, either lessor or either mortgager, if they are going to transfer their property, then they can transfer only to one person. Section provides that property can be transferred to more than one person also. So it means to group of the person also property can be transferred. Thereafter, this section says that property can be transferred to himself also, and this is possible only in those cases where the trust is created. So, for the beneficiary of any other person, if the trust is created, then the property can be transferred to himself also. Now, we are talking here again and again about the living persons. So, living persons includes company, association, body of individuals, whether incorporated or not. So it means living person includes both the persons, natural persons as well as juristic persons. So this is the definition given under Section 5 of Transfer of Property Act of the term transfer of property. Thank you so much.